You're adding into the process a new actor, and so then it generates different questions in terms of how they fit within the established sort of rules of the game, I suppose. And it is still relatively new, particularly in arbitration. Also, I think because it's not a publicly disclosed process, those who have been through it don't necessarily share how it's worked with others. But privileged information and confidentiality, we conduct ourselves and we maintain the same levels of confidentiality as a client would with their law firm. So we're either conducting very early discussions on a strictly no-names basis, or if we move beyond that, we have entered into a confidentiality and common interest agreement with the client. So then information can be shared, but within the same parameters that you would be with your law firm. So I don't think that's a cause for concern. Also, you'll see in many of the legislative changes, and in Hong Kong in particular, they have clearly said that disclosure of information to the funder is covered under the ordinance and will not take you outside of the normal expectations. So that's very important. I think we then talking about disclosure, this brings up, it's very much discussed. I think often people think that funders have a problem with disclosure. From Harbour's point of view, that's absolutely not the case. We do encourage our funded parties to disclose that there is a funder involved and our name, that we are, backing that case. They may not want to for their own reasons, but that's not a hesitation on our behalf. So we're very much in favour of disclosure, which also leads on to another issue of conflict of interest. Very much funders want to avoid any conflict of interest. It's of absolutely no use to us to invest in a good case, to get all the way down to the end, to have an award issued in your favour, to not be able to enforce it because there's a conflict of interest. So, we are very aware of those issues. We very much want to avoid them. We have no reason not to want to disclose our involvement. And then I think the last part of the question was undue influence. That comes down to how your funder will be involved in the case. Harbour, as a member of the Association of Litigation Funders, does not control the proceedings once it's invested in them. We pay the bills on a monthly basis and we contribute our experience to the extent that it is useful and relevant. But essentially the strategy and the running of the case stays with the client. So they are free to proceed as they wish. I think people get concerned about settlement and what kind of role a funder might have. Again, I can only speak from Harbour's perspective. But again, that's a decision that very much rests with the client, what they want to do. They obviously need to think about what's in their own best interest, and they will have to have regard to the funding agreement they have with us in considering that. But very much it's within their prerogative. We are very happy if a settlement is made, because for us certainty is better than proceeding through and you don't know what the outcome is going to be. But equally, we're not trying to force settlement to take place if it's not suitable. So we want settlement to be within the minds of the client and the lawyers throughout the case to think about when it might be suitable to have those discussions and if it makes sense to settle the case. But it's not within our control.